The broadcast is now starting. All attendees are in listen.
Okay, welcome everyone to the January 2019 webinar. My name is, I'm gonna go here. My name is Kevin Mosher, that's me. And it's an updated photo. We recently got updated photos. For those of you who watch the Thompson Co. website, which religiously, which I know it's probably most of you on the webinar here today. You'll in the future see updated photos for everybody. So suddenly your lovely attorneys are going to have aged significantly since their last photos. Anyway, here's my significantly aged photo. I'm excited to present the first 2019 webinar, the HR Best Practices webinar series. We are in our 7th year, I believe, of doing these, and I'm really excited about it. I am going to be your presenter. I'm a certified specialist, Minnesota State Bar Association in labor and employment law, and all day long I advise businesses on HR compliance. If you are new to the webinar, welcome. I really appreciate your attendance and attention. We will. You are welcome to ask questions if there are opportunities. I'll scan through the questions. This is not an open webinar, so if you raise your hand or want to speak out loud, it's not going to do any good. I'm not going to be able to hear it. But you are welcome to write in some questions, and if I have the opportunity, or if it's something I haven't already covered, I'll definitely try to scan through those and email them or respond to them as appropriate. That would be on the right side of your control. Also, when you registered, if you forgot to click the box that you need HRCI or SHRM credits, just send us an email or give us a call, and we'll be happy to verify your attendance and get that certificate out for you for 1 credit, since this is a 1-hour webinar. Okay, we do have again, for those of you who have been on these over the years, we are implementing a new format. This is our the last one that we're going to do on GoToWebinar. Next month, we're switching over to On24. So there'll be a little bit different registration system. If you're on the email list, you just get a link. You probably won't even notice all that much, except the registration will be slightly different, but it'll be through On24. So you want to make sure that in advance your computer's compatible, and whatever needs to be downloaded, if anything, is downloaded, since this will be the last GoToWebinar format. So really excited to talk about this one. At the beginning of every year, we have one of these, like, okay, what happened last year? What are we looking at this year? And so it's kind of a review. It's a prognostication. And so we're going to talk about a lot of different things. We're not going to get too deep into any one of them. Next month, we will be talking about accommodations, ADA accommodations in the workplace, disability accommodations in the workplace, and we will get very deep into disability issues and accommodating employees. But this month, we are going to talk about a slew of things that occurred in 2018, and we are going to talk about what's more likely to be a more energized and slew of things that are going to likely occur in 2019. It is almost always the case that in the 3rd year of a presidential administration that things finally start to happen, at least on the employment law side, on the HR side and labor law side. It just takes a while to go, well, first of all, it takes a while to figure out the agenda. It takes a while to figure out the strategy. It takes a while to move new people into agencies and into positions and learn what they're, now in charge of. And then the regulatory process itself. And so once you get those people in place and you figure out strategy, and some things are more prioritized than others, then you start to even talk about rulemaking and regulations. And so as a result, it's very, very common that for most presidential administrations, you are not looking, it's this third year. It's after the 2 full years, and then it's going into the third year where you start to see some real movement by these agencies, whether it's the EOC or the Department of Labor or the NLRB. And I fully expect that that is going to be the case. We already know that a number of regulations are coming down the pipeline. The same thing happened with the Obama administration. Things did not happen overnight. In most situations, it took several years, and it was toward the end of his first presidential term, and it was toward the end of his second presidential term that we started to see a lot of stuff come out. So this year, I think, will be exciting. Not much is likely going to. I mean, there'll still be things in 2020, but with the election, it's just going to be just crazy hard to know if anything is going to stick in 2020. If there's just a lot of political turmoil and changes. So we are going to talk about what happened in 2018. We're going to talk about what's going to probably happen in 2019. I'm not a complete soothsayer on this sort of thing, but I think historically, if you watch these webinars, I think I've been pretty accurate on what ends up being the big topic of the year with regard to HR. Okay, before we get that, just wanted to introduce you. It's 2019, it's a new year, so a lot of you don't probably know about our myHRgenius program, and so I would definitely want to make sure that everybody knows about it. It's starting at $79 a month. It's a all-you-can-use HR legal hotline to Thompson Co. So if that's of interest to you, we obviously have higher packages as well that include a lot more legal services, especially at the $99 level. It's a lot with the model HR documents, but it's a month-to-month program. If anybody is interested, if you are not currently a participant in it, it's an incredibly valuable legal HR resource for your business. And the included in that is what Thompson Co. does, which is in addition to the hotline, the myHRgenius program with that legal, we do a number of webinars outside of HR. We also offer full gamut of immigration support, HR support, and obviously legal representation in court and agencies and that sort of thing. Okay. So let's look at, here's the outline of what we are going to talk about today. So these are the general topics. So I suspect we're gonna glance at a few other things along the way, but I don't think it's going to come to any surprise to anybody that 2018 was full-fledged Me Too movement. So Me Too really started in kind of the last Q4, end of Q3 of 2017, but it really was in 2018 that we started to see the full effect across the country, and I think that's going to continue. So a lot of the 2019 predictions, a lot of them are going to be a continuation of what we saw in 2018. 2019, I fully expect that we're going to continue to see more and more and more litigation, more and more agency, federal and state agency activity going after employers. And I think you're going to start to see larger and larger verdicts against employers for sexual harassment, hostile work environment, gender discrimination, types of claims and lawsuits against employers. I expect that's going to continue for a while. And so we'll talk about minimum wage. There's been a lot of movement, not at the federal level, but at the state level, at the local level. Talk about some NLRB stuff from 2018. And then for 2019, I think 2019 there's going to be more substantive stuff on immigration. There's been a lot of talk on immigration, and there's been a lot of action too, but then the courts stop things. And so immigration, I think from an employer perspective, I think is going to be a bigger issue than it was in 2018. Immigration was certainly an issue in 2018 with regard to, obviously we're talking about, walls right now with the federal government being partially shut down. But with regard to employer type of stuff, like raids on businesses by ICE, going after employers for failing to do I-9s correctly, fining employers, even pursuing criminal charges against employers who are employing illegal immigrants. I think we're going to see more and more and more of that. What's getting the headlines right now is they're closing down borders. They're talking about closing down other borders. They're talking about not bringing in people, but that's not as much employment-based immigration. That's more like non-employment based, family-based refugees, asylees, that sort of thing. Which, not to say that we don't care about that as employers, but that's not as directly related to our world. And then we'll talk about a lot of other things that are likely to come down the line with regulations regarding equal pay and maybe even a federal minimum wage. Who would have, with the Democrats in charge of the House, guaranteed if we didn't have this whole budget shutdown thing and conflict right now, I'm almost certain that minimum wage would be top 5 strategic items right now in front of the House of Representatives in Congress. And I think once the budget, if and when this whole shutdown ends, I fully anticipate that we're going to have a national conversation about minimum wage. It's not going to go anywhere in the Senate, but I think we'll at least have a conversation, and the Democrats will use that as a rallying cry type of issue. Okay, 2018. So, again, I don't think this is going to come to any surprise to anybody who's been paying attention for the last year and a half, but sexual harassment lawsuits filed by the EEOC, still only 41. It's still a big increase. The EEOC does not file a lot of lawsuits. They really file very, very few lawsuits. The fact that they filed 41 lawsuits regarding sexual harassment, gender discrimination in the workplace is fairly telling of their priorities. There has been a serious increase, as you can see, 50%, 7,600 charges filed against employers for sexual harassment in 2018. That's a pretty serious number as well. So I think across the board, what is the EOC seen? And what the EOC has seen is a reflection of American society. It's a reflection of how employees view their rights and what they expect in the workplace. I've noticed just generically a lot more complaining from employees about just harassment in general. And it's always kind of been there. Just employees use the word harassment. They use it very, very loosely. So a lot of times employees will talk about harassment and what they really mean is bullying, or what they really mean is that person said something I don't like. Well, just because somebody says something that you don't like, that doesn't mean it's unlawful harassment. It has to be, for it to be unlawful sexual harassment or hostile work environment, it has to meet a number of criteria that are pretty difficult to meet when all is said and done. As you can see, from 7,600 charges, only 41 lawsuits from the EOC came from them. That's actually not a huge number, but it is, from EOC standards, a pretty big number, because as you can imagine, out of these 7,600 charges that were filed, a lot of them are pretty frivolous. And I mean, I just know the ones, that we see all the time, very, very often, very frivolous. So people are a little bit more in tune to what they believe their rights are under Title VII or under state laws with regard to harassment. So I think you're going to continue to see this awakening, this realization that, hey, that's not, I don't need to be treated that way. And sometimes it's going to be warranted and justified, and there's going to be some legitimacy to the complaint. And a lot of times it's going to be frivolous, as it always has been. But I think we're going to continue to see greater and greater activity on this. Minimum wage. Okay, so like I mentioned before, nothing going on at the federal level, but at the state level, the last 6-7 years, we have seen a lot of activity on minimum wage. And for those of you who religiously listen to these webinars, we talk about minimum wage, we talk about paid time off, we talk about a lot of these issues that are really hitting the states. And in the last several years, mainly the last 5 years, it's been mostly talking about actions that have been taken at the state and local level. The federal government has done very little with regard to changes to employment laws. There have been regulations at the executive level, and there's been executive orders, and federal contractors have had a lot of changes, and And there's been regulations from the Department of Labor, and then NLRB's had a lot of decisions, but those are at the executive level. So those are like, by fiat essentially. And President Trump is doing just what, President Obama did and President Bush did before, which is getting frustrated with Congress because Congress can't seem to agree on anything, or the president can't agree with Congress. And so just, executive decisions by order, by fiat. And, all the presidents do it, but most of the substantive changes, especially with regard to minimum wage and paid time off, have occurred at the local level. So we are seeing, across most states now, not really in the South, but most states throughout the rest of the country, cities and states have made a big push to raise their minimum wage. It's really, like I say, it's really outside the South. Most of the country has seen quite a bit of movement on local minimum wages. And in St. Paul, we just increased ours, or will be increasing. It'll be phasing in over several years. The $15 minimum wage here in St. Paul, which matches what Minneapolis did. But really, the California cities, which makes sense, it's so much more expensive to live out in like Seattle and Sacramento and San Francisco and that sort of thing. So it makes a lot of sense that they were kind of the first ones to start getting the minimum wage going. But we expect fully that this is going to continue. Ultimately, eventually they're going to run out of states that are willing to raise their minimum wage. I do think we're going to get something at the federal level at some point. It's not. I mean, it's controversial just because every political issue seems to be controversial these days. But really, there are Republicans out there that have at least talked about being open to the idea of a minimum wage, just like there's a Republican or two out there that have talked about being open to some sort of paid time off scheme that would grant whether it's an insurance bank for employees to dip into like we have in the state of New York, or if it's just employers need to provide paid time off. There are some Republicans, very few, but there are a few out there. So there is some potential on minimum wage and on paid time off. There is some potential to maybe even get compromised. Like, oh my gosh, amazing. But yeah, there that could actually happen in the future. I don't have any idea where the president stands on that issue. Probably opposed to it, but I really don't know. So like I said, we haven't seen it. It's been it'll be 10 years since we've seen a minimum wage increase. The other thing that we've seen in the last several years, it carried over in 2018, it's going to carry over in 2019 and in the future, is tying these minimum wage changes to the consumer pricing index or some sort of other neutral statistic increaser, so that the governments don't have to continue to look at this every few years once the minimum wage becomes obsolete due to just constant inflation. So most states that have done this, most cities that have done this, have tied it to some sort of increase that's just automatic. And the consumer price index is the most common one, but I think if you're going to start to hear this debate in Congress, if you're going to, and like in your locations in states, you're going to see that's going to be a big component of it. Are they going to peg automatic increases to consumer pricing index or something similar, so that they don't have to continue to deal with this every 5-10 years? Like I said, I think if we weren't talking about a shutdown right now, you'd be watching this on CNN. There would be, the talking head debates on all the news stations and everything, talking about minimum wage and the pros and cons of a national minimum wage. NLRB. Okay, so switching focus, we've seen a lot of movement from the National Labor Relations Board. I would say they're kind of starting to get their feet under them in 2018. There is a process within NLRB with replacing the members of the NLRB, and it's not one of those things where it happens automatically when a new administration comes in. There is a revolving door, and these people, the members, they are there for terms. So it kind of takes, it's normally in later into a new presidential term that we start to see some real changes on the NLRB, and we really started to see them in 2018. So just some of the highlights from the NLRB, and if you're not super familiar with the NLRB because you don't have a union, then that's okay. Most of these rules, because the National Labor Relations Act itself, it applies to non-union employers. So if you've got multiple employees, it's still going to apply to you. It's just not going to be as relevant because it's not going to come up as much. But for example, the handbook rule during the Obama administration, it was quite a big deal. I remember doing webinars and our tips of the week and everything like that on this. But the Obama administration, NLRB, started issuing a series of rulings. They were ruling on decisions from the regional offices, and they started to really confuse employers, because they started to look at handbooks, and they started to look at the language in handbooks and what do policies look like and what do the policies say. And the Obama, just kind of synthesizing about several years of decisions, the Obama NLRB, the Obama board, basically came down and said this: if a rule could potentially be interpreted as restricting somebody from wanting to engage in protected activity under the National Labor Relations Act. And what is that? That is when two or more people get in concert, complain or try to get change to their terms and conditions of employment. So two or more employees. Normally we talk about those people as unions, but you don't have to have a union to be engaging in protected conduct under the National Labor Relations Act. So the NLRB would look at all these handbooks, and the NLRB would say, could this rule potentially be such that an employee could, in a theoretical world, read it and say, oh, I don't want to go in concert with one of my coworkers. I don't want to talk about my wages because I'm going to get in trouble because there's a policy that says no talking about wages. Now, a lot of states prohibit that practice anyway, but a lot of handbooks back in the day had policies that said you can't talk about your wages with coworkers, or the policies might have said that if you have complaints about coworkers or management, please, you need to come to HR and do this sort of thing. Okay, so there are a bunch of, we can go on and on forever on the potential policies that could be out there. So that was a problem because a lot of these non-union employers were now getting charges under they're being investigated by the NLRB. They're getting charges saying that their language is potentially discriminating against people for wanting to engage in their rights under the NLRA. So this was a good change, personal opinion, on from the new Trump board. And so this last year in 2018, they said they listed a number of categories of policies that could not reasonably tell an employee that they can't engage in protected activity. So things like a non-disclosure. So and I'm struggling for examples, but there's a whole list. If anybody wants to know what the list is, let me know. But some of the NLRB in 2018 still said that no, if an employee would interpret the language as discriminating against them and their rights under the NLRA, if it would, then that would be a problem, and then the NLRB would come down on the employer. But if it's just theoretical, if it's just like theoretically they could interpret that rule, then the NLRB is not going to care anymore. So they really watered down, and they've really given a lot more ability for employers to have better language that's more restricting and just better language in their employee handbooks. Okay. Social media, we've continued to see with social media as the advent of social media, but we're still seeing that the click of a like is still potentially protected concerted activity. So if you've got two coworkers and one is complaining about, the heat in the office making him, have a really difficult time working and sleepy, and it's really a problem in the office, and he's like, I'm going to go complain about it to the supervisor tomorrow, and you have another coworker hit like to that, Facebook post or whatever, then those two engaged in concerted activity. It seems weird, right? But that's the world these days, and so we still have to be careful of that. We want to make sure that if we see, even on social media, employees complaining about the terms or conditions of employment, that we don't just knee-jerk fire them. We really have to examine it. It could potentially be a violation of the law. The other rule that's coming, there's going to be a proposed rule coming out in 2019. This is coming on joint employers, and that's a big deal, especially if you're in the staffing industry or if you use staffing employees. And so, under the Obama board, they changed the rule. They had a big decision called the Browning-Ferris Industries decision, and in that decision, the Obama board said that if there's this apparent authority out there between the end user company, whatever the end user company is, and the staffing agency, where the end user company could assert some sort of control over the employees, even though the employees are technically employees of the staffing agency, then under Browning-Ferris, they were joint employers for purposes of the NLRB. The Trump board is almost certainly going to issue a rule this year that said that changes that and waters it down so that it's only going to be a joint employer situation where the staffing agency and the end user employer, where the end user employer is actually asserting control. So not just like theoretically could assert the control, but actually does assert the control and supervises and is does a lot of the things that a typical employer does, like supervises, controls terms and conditions of employment, that sort of thing. So it's going to be a much harder now under the new rule that we expect to come out soon in the next few months. It's going to be much harder for there to be a joint employer situation where both employers are required to bargain if there's a union, that sort of thing. Okay, those are kind of the highlights on the NLRB. Department of Labor, we actually didn't see a ton from the Department of Labor in 2018. There was some stuff on tips that was kind of a big to do at the end of 2017 and then going into 2018, and then Congress kind of cut a deal, I guess, with the Trump administration. The Democrats cut a deal with the Trump administration to undo the rule that the Department of Labor. So now it's harder to potentially have an employer keep the tips. So the new rule proposed by the Trump administration was going to potentially allow for the potential for employers to keep tips and to extend tips to people beyond people, like a tip pool beyond people that are just customarily receiving tips. So it's now back to a situation where it's where employers don't have as much control over the tipping pool. We also, the biggest thing probably with the Department of Labor that we got was a solidifying of the independent contractor rule. So we're back to the economic realities test. Now, there was an opinion issued with regard to caregivers, but we think that the economic realities test, it has the same application, and the courts apply that test all the time too. So the test that the Obama Department of Labor had implemented that watered down and made it much, much harder for employers to claim that the person was an independent contractor. We now have the more historic standard that the courts historically have looked at as well, of the economic realities test, which looks at a number of factors, and a lot of the factors overlap, but we really look at, like, at the end of the day, does this person, this independent contractor, do they seem to be an independent contractor, or do they seem to be an employee? And we're going to look at a number of things to figure that out. But the economic reality test is a good win for employers, and so it was good to see the Department of Labor move back to that test. We also have a little bit of a clarification under the FMLA regarding organ donation, and how generally they're going to qualify for FMLA leave, but really they're likely to qualify as a serious health condition anyway, since there's potentially with organs probably overnight inpatient treatment. Though I am not a doctor, so I guess I'd like to think that I'd probably stay overnight though if I give an organ. So that probably happens. So anyway, most organ donations are either way they are going to be covered by the FMLA for eligible employees or eligible employers. Immigration. In 2018, again, we saw a lot of talk about immigration, and a lot of the fears with regard to at least the employer side of immigration haven't fully come to fruition. We have seen pushback. It is harder to get visas today than it was to get them in 2017, 2016, 2015. And by the way, as an aside, if you do need to get H-1B visas, now's the time. So give me a call or start to work on it, because H-1B visas are still in play. So all applications for new H-1B visas need to occur on April 1. So you really should start planning no later than like February 1st, maybe even February 15th at the very latest. Otherwise, there's potential you could be shut out from new H-1Bs. But otherwise, the rules haven't changed for H-1Bs. So we want to definitely be mindful of that and get your applications in by on April 1st. They did change it last year with regard to the lottery. So in previous years, the Immigration Department of Homeland Security had allowed applications for H-1Bs, and they said, like, all the applications that come in that first 5 days, that first 5 business days, we're going to take all of those, because there's always like 3 times or 4 times as many applications as there are actual visas. So your chances are always about 25 to 30% of even getting selected. And so they said, like, oh, we're going to take all those that come in that first 5 business days, and we are going to then give them all a number, and then we're going to, do a lottery, and we're going to pick them. Well, the Trump administration said, much to everybody's surprise, well, that's not a guarantee. And then they just closed it down after, I want to say 3 days or 2 days, but they just closed it down. So, I think a lot of people were expecting to have a couple day grace period, and they didn't get that in 2018. I don't think they're going to get it in 2019. So if you're going to do an H-1B visa, it better get there on April 1st, April 2nd at the absolute latest, but don't mess with it. Get it there on April 1st for work authority starting on October 1st of 2019. We have seen an increase in denials. We have seen an increase in RFEs, which are requests for evidence. On H-1Bs, there's just generally a lot of pushback. They also got rid of the premium processing. It makes no sense whatsoever, but they did it. It's free money to the government, but I guess they don't want the free money. So they got rid of premium processing. So that certain immigration visas could not be expedited. And with $1,225, you get a decision within 15 days. And they, got rid of that for a number of visas, including certain H-1B visas. We've seen a general denial. So there's a lot more pushback on visas. It's just the way it is. And in a few years, it might be completely different, or it might not. We don't know. But today, right now, it's a hostile work environment for, not unlawful, but it's a hostile work environment for, with the government in applying for any sort of workplace visa. We have also seen getting rid of temporary protected status for people from El Salvador, Haiti, Nicaragua, and Sudan. A lot of that termination of temporary protected status has been put on hold. So the administration's been doing a lot of stuff on immigration. with regard to, especially with regard to non-employment immigration, but a lot of it hasn't stuck because it's either been poorly drafted, they didn't follow proper procedures in implementing the rules, or the rules are just straight up violations of the Constitution. At least that's what it gets argued, and courts seem to be agreeing for the most part with any of those circumstances. So I suspect the administration will figure out how to do things in the next couple of years if they haven't so far, which might be why you've seen a slowdown in a lot of these kind of knee-jerk changes and rules. There's just been, there's a process that needs to be followed, and a lot of times it wasn't followed, and the courts have kind of stalled it. But I think they're probably figuring out how to play the game and do things legally. So I think we'll probably continue to see more and more, TPS status being denied and terminated for people from all over the United States. Foreign students, this has been the one that's kind of been unfortunate and surprising. It used to be just an absolute slam dunk no-brainer that you would get the ability to work after graduating from a U.S. university, as long as you worked in your field. So if you're an engineer, you go and get an engineering degree, and then you find a company or you're a company and you want to hire a recent grad who's from some sort of country that's not the United States, and you want to hire them, and they've just recently graduated from a U.S. university, you can bring them over on an F1. It's called OPT, or Optional Practical Training, and you can bring them over to work for you. You don't need a visa. Like they just get the ability to work for 12 months, and if it's a STEM program and it's a STEM job, and you're enrolled in E-Verify, then you can get them for another 29 months. So it's a really great deal for companies who don't want to, pay the costs and everything of getting an H-1B visa. And then it's just really easy. But what we've seen is that the Trump administration's they're making it harder for these F1 students. A lot of times they're just not approving things. And then as a result, and because it's harder to get the H-1Bs, they can't switch over to H-1B status. And so they're getting out of status, which means that they have to leave the country. And if they're here working out of status, then they could be barred from re-entering the country for anywhere from 5 to 10 years, depending on how long they worked without status. And if you employ somebody without status, then you violated immigration laws as well, and you could be fined as an employer. So the delays that we've seen from immigration, a lot of stuff is just being slow walked, and it's unfortunate, but it just is. It's being slowly walked through the administrative process, and it's just unfortunate. A lot of people have had to leave the country that are highly skilled as a result. Okay, 2019. So this is the big issue. We've talked about this a number of times over the years. There has been, right now as it stands, Title VII, which is the Civil Rights Act, Federal Civil Rights Act, does not cover sexual orientation. So if you were to say, is it illegal under federal law to discriminate against somebody because of their sexual orientation or gender identity? The answer is yes. It is not discriminatory. I'm sorry, I don't remember how I asked that, but it is not discriminatory. So you could technically not hire somebody because of their gender identity or their sexual orientation. However, so Title VII, it does not say sexual orientation. A lot of state human rights acts do. A lot of city ordinances do. So if you're in Minnesota, it's been like that for 20 years now, that you can't discriminate against somebody because of their sexual orientation. That's been very clear, and a lot of states have said the same. But under federal law, it's never been clarified. There's never been an amendment. The EOC under the Obama administration took up the position that Title VII did protect people because of their sexual orientation and gender identity, and it did so because of the way that because Title VII does protect against sex discrimination. And so the EOC under the Obama administration said, well, Title VII prohibits sex discrimination. And really, we're talking about sex when we're talking about sexual orientation and gender identity. Therefore, sex discrimination, when broadly read, prohibits discrimination based on sexual orientation and gender identity. And some courts agree, and some courts don't agree. And so there's been for many years now, and now we have a new EOC and the Trump administration, and so we are. So it's probably going to happen sometime soon that the U.S. Supreme Court looks at this and helps us out a little bit to understand. Now, the reality is that I don't think there's probably many or any attorneys out there that would advise their companies to that go ahead, don't hire the person because they're, transgender or something like that. Like, I just don't think it's not. First of all, you're likely to end up on social media. There's something that's going to go viral. It's not going to be good publicity for the company. So even if it's not illegal, it's probably not a good practice. There are just a lot of people in this category. And so you're excluding a large pool. So there are some pragmatic reasons for not doing this. And also a lot of cities and states around the country prohibit it anyway. But technically it's not illegal under federal law. With a strict reading of the federal law, and so jury's kind of out on what the federal government, how Title VII is going to be interpreted. Hopefully, the Supreme Court will take it up. Equal wages, we will continue to see more and more at the state level, at the federal contractor, at the state contractor, and did I say the federal level? At state and federal level as well with contractors, we're going to continue to see equal wages. This is a derivative aspect of the Me Too movement. And there's just a lot of statistics out there that show, at least for women who are in their like mid late 30s and older, that there is just a differential in a beyond statistical variability. There is a lot of anecdotal and statistical evidence to show that there is a gender wage gap based on gender. And so we're just going to continue to see cases on this. I think there's a lot more. Well, first of all, there have been a lot of really large verdicts out there by courts where employers have been tagged for equal pay violations. I think we're going to continue to see more and more legislation on this. I think the government is also keenly aware of this issue and wants to make sure that they're doing work with contractors that are following equal pay rules. And this again comes from a lot of the energy behind this is coming from the Me Too movement, and we're just having a general demographic change in the workplace. I mean, I think it's been a long time now that women have been the majority of the workforce population, and now especially as we have a younger generation and a lot of these millennials and Generation Z coming in. Well, a lot of these expectations that might have been under the baby boomers, where you might have excused some unequal pay over the decades, because just coming from a different time and era, it was a little bit more accepted. I'm not saying it's right. Obviously, not. I would say, in fact, it's not right, but it was more accepted back then, and I just don't think that same expectation holds true for the younger workers in the United States and the workers that are coming down the pipeline. So I think we're going to see more and more activity on equal pay, and I think a lot of companies are being very proactive in doing their own internal auditing and analysis on equal pay issues. Department of Labor, we will see in 2019 an overtime rule. So it's been a while. And those of you who remember the quite amazing and surprising federal court decision out of Texas, some judge in Texas who said that, put a stop to the Obama implementation of their new overtime rule, completely nonsensical in my opinion. But anyway, because the Trump administration then quickly took over the Department of Labor and everything, so that decision, that injunction from that Texas judge ended up standing. So it was going to implement at about $47,500 for the new salary basis test, and that was going to be at the end of 2017. And if you were doing HR like I was back then, you were doing a lot of preparing to move salaries. You were doing salary analysis to see, okay, who are we paying under this $47,500 threshold, which is the new salary basis threshold, and who aren't we, and who do we want to continue? Because if you had a white collar worker and you wanted to continue to call them exempt from overtime, you were going to have to meet the salary basis test, which meant paying them at least $47,000 and almost $500. So that, they did away with that, and so we reverted back to what has been the current salary basis test, which is a little over $20,000. Well, a little over $20,000 is, very low wages, and certainly almost all exempt employees, people that we would call managers and professional staff and most administrative workers, easily make over $20,000 to satisfy this salary basis test. So that's where we are right now. I think there's still some desire. In fact, I know there's still some desire from the Department of Labor, even under this administration, to still move that upward from $20,000. It's $455 a week, so it's at minimum at least $455 a week. We don't know what the Trump administration wants to do with this. There's been a lot of talk. Some talk has been about getting rid of the salary basis test entirely, so no more salary basis. So just pay whatever, but you got to meet these other duties, the duties test, or maybe they'll change the duties test. Hard to know. In a speech, the Department of Labor head said something about around $33,000 being a good number, because when you peg it to inflation, since the last time this went up, and I think 2008, maybe not, maybe it was earlier than that, but it's been a while. So since then, if you look at inflation, inflation would take it to around $30,000 to $33,000. And so that's been kind of a little bit of an expectation, like, oh, well, maybe that's going to be the new salary basis test. But really right now, it's all speculation. We don't know, but stay tuned. We're going to get some preliminary proposed regulations, and it'll be very exciting to see what happens. And for those of you that are on the myHRgenius program, you'll get your tips of the week and everything, and we will have a lot of discussion on that. I'm sure we'll have webinars on it as well. So that'll probably be the biggest thing from the Department of Labor this year. Some other stuff that's not as, it comes up, it's important, but it's not as widely impactful as the other, as the overtime rule is. There's going to be some new regulations. The EOC tried to go, they just went a bridge too far on some regulations, on some rules in 2015 that were quickly overturned by the courts. And so it's just one of these, there are rules out there, and we're going to get some clarity on those rules on, what are the circumstances where employers can collect health and genetic information from employees. Does it have to be voluntary? How much can the employers ask for it? And this is all kind of driven by these wellness programs and trying to get the information necessary for the wellness programs, so that employers get employees to participate in the wellness program, so that they can get the maximum so they can get some deductions and cost savings on their group medical insurance. And they want to entice employees with incentives to participate in these wellness programs, so that they have a healthier workforce and population working, so that they have fewer costs, right? And I'm sure because employers like employees to be happy. Okay, so let's focus a little bit on immigration, because I think we're going to have some need to understand expectations for immigration in 2019 if you're not fully up to speed on rules and how immigration can affect you. So the entrepreneur thing doesn't have a ton of applicability to most of you, but what we really need to understand is ICE. ICE and Dreamers are still a thing. It hasn't been talked about, except that the Trump administration, and I'll switch back to ICE in a second here, except that the Dreamers with DACA, that has come up in the talks on this, the budget shutdown, the government shutdown. So one of the more recent proposals was that the Trump administration would give the Democrats everything they want on the Dreamers, and in exchange for the wall going up, the funding for the wall. But the reality is that the courts have already kind of told the Trump administration they can't do what they want to do on Dreamers, and so I guess it's the Trump administration basically is offering something that they don't have to offer right now, which is a deal on the Dreamers, but the courts have already shot down everything the Trump administration wants to do on the Dreamers for the most part. So let's focus on ICE. So ICE is continuing. So not only do we have immigration, we've got the border and all that, but ICE has switched back. It's just a moving target. It happens every few years. But right now we are going through a heightened period of workplace enforcement by Immigration, Customs, and Enforcement. We are seeing huge increases in I-9 audits. If you haven't been through an I-9 audit, let me know. They're fairly detailed. They're pretty cumbersome. You should be doing I-9 audits every year if you have a lot of turnover, every other year if you don't. And so definitely you need to be up to date on I-9 audits. We want to be clean on I-9 audits because there's been a lot more activity from ICE raiding employers, doing I-9 audits, finding employers, and also then, arresting and pursuing criminal charges against managers and business owners and people who are part of employing illegal immigrants. Now, if you've got a potential illegal, now the thing is with illegal immigrations, you need to know, right? And so knowledge comes from circumstances or it comes from direct information. You need to know if the person's illegal. So if you don't know that anybody working for you is illegal, then I wouldn't start to figure out how your jail time is going to be, and start to get some good books for that. I wouldn't worry about that so much. A lot of really where the criminal charges come down is when it's very, very clear that, and the government feels assured that the employers knew that they were employing illegal undocumented workers. But it does focus on criminal prosecution. So right now, when they're doing raids, they're not just rounding up illegal workers. They're also looking at employers, at managers, at owners, at HR people to make sure that and they'll come after you if they find out that there was some knowledge there. So you need to have a strategy, especially if you are employing illegal workers. Definitely need to have a strategy in place for moving away from that if you have any concerns and if you feel like that's too risky. Here's an idea on the increases that we're seeing. So criminal worksite arrests, that's 779 white collar managers, owners that were arrested for it's not a lot when you look at it nationally, but it's a whole lot more than it was in 2017. Now the interesting thing is, as much talk as there's been at the federal level by the president and mainly the president about immigration, 2017 was a major dip. So the Obama administration was doing way more investigations and I-9 audits and deportations and all that sort of thing. During the Obama administration, and then it actually dipped quite a bit during the Trump administration, and then I think he heard that it dipped quite a bit, and they, like I said before, it takes a while to get your feet under you, and they did with immigration. So you can see the effect of getting their feet under them and getting a lot more funding. They are doing a lot more. There's a lot more risk today than there was 2 years ago that you're going to be audited, that you're going to be investigated. You should have some sort of immigration protocol. So here's what to do. So I will just give you kind of a primer on what to do if you are one of those last year's almost 7,000 employers that were raided by ICE. So what do? You got to see the warrant. There is the potential to fight against the warrant. If it's an I-9 audit, you've got 3 days. And that's why we have to have our I-9s in really good shape, because you get 3 days. And if you've got hundreds and thousands or even thousands of I-9s, they better be in good shape. You're not going to have time to update them. 3 days is just not a lot to go through all those. And then to get with the employees and to make sure you've got all the workplace documents and that the form itself is filled out, that sort of thing. That's a huge rush. Sometimes you can get Sometimes you can get a little bit more notice, but for the most part, they say that they're coming over and they're going to want copies and they're going to take the I-9s with them, and they give you 3 days and then that's it. You want to make sure that you've clearly got legal counsel, that you're putting together a media statement if it's a raid, so that you've got something to go to the media with, because a lot of times the federal government contacts the media and tells them to be there so that they can be there with cameras showing them taking you off in shackles, or that, a little facetious, but it happens. I mean, there was that picture 2 slides ago of immigration doing exactly that, and they did that with 800 people last year. So hopefully not you, but there's always the potential out there, I guess. And so we want to make sure that we have a media strategy. We don't want to consent to anything. Your legal counsel should be on the phone with these immigration officers. If there's a raid, if there's an audit, it should all go through legal counsel. But you definitely don't want to consent to anything, because if you say, yeah, go ahead, go into the back room, then they can. If they don't have a warrant, they don't have access to your property necessarily outside the same areas that the public has access to. So you want to be really, really careful, like not to overgive the federal agents. They have rules. There are restrictions on what they can do with regard to their raids and taking away documents and employees and that sort of thing. We definitely want to have training, and we want to document everything, all of our dealings with the ICE agents if we are ever raided. So here's a really quick primer on kind of steps to take, but you should overall have an immigration plan in place to do. And the one thing, okay, so that's what I wanted to talk about. But I will say this: we've got a couple minutes. I will say this: there's one other trend that I wanted to mention that didn't end up in the slides, and that is with regard to non-competes. That is something else we saw in 2018 and in 2019 with regard to non-compete and settlement agreements. I should say settlement agreements, where some states, California mainly, and then the federal government have started to put restrictions on non-disclosure, on confidentiality provisions in settlement agreements, and that's all stemming from this Me Too generation as well, where there is a tax disincentive now for having non-disclosure language in a settlement agreement when the claims were for hostile work environment, sexual harassment, and same in California. California just passed, going into effect this year, a rule basically saying that same thing, that severance agreements, settlement agreements, where there's a Me Too, where there's a harassment component to it, that there's a number of things that need to occur in that agreement that don't prohibit the person from talking about it. So we don't, these muzzle type of policies and rules. There's a lot of pushback on those. So I think that's something that's kind of the last thing I wanted to talk about with 2019, where I think we're going to start to see more and more of that around the country, and even at the federal level, we're starting to see that. So there it is. There's your first HR webinar for 2019. I appreciate your attendance. And if you have any questions on the webinar or the myHRgenius program, or want to register for the next webinar, feel free to give me a call or shoot me an email. And I appreciate it. Thanks for your attendance, and we will see you next month.